Now, in these instances, and in other cases where the courts pronounce upon the validity of a bylaw made by a body, e.g. a railway company or a school board, having powers to make bylaws enforceable by penalties, it is natural to say that the courts pronounce the bylaws valid or invalid, but this is not strictly the case. What the judges determine is not that a particular bylaw is invalid, for it is not the function of the courts to repeal or annul the bylaws made by railway companies, but that in a proceeding to recover a penalty from X for the breach of a bylaw, judgment must be given on the basis of the particular bylaw being beyond the powers of the company and therefore invalid. It may indeed be thought that the distinction between annulling a bylaw and determining a case upon the assumption of such bylaw being void is a distinction without a difference, but this is not so. The distinction is not without importance, even when dealing with the question whether X, who is alleged to have broken a bylaw made by a railway company, is liable to pay a fine. It is of first-rate importance when the question before the courts is one involving considerations of constitutional law, as for example when the Privy Council is called upon, as constantly happens, to determine cases which involve the validity or constitutionality of laws made by the Dominion Parliament or by one of the provincial parliaments of Canada. The significance, however, of the distinction will become more apparent as we proceed with our subject. The matter of consequence now is to notice the nature of the distinction, and to realise that when a court in deciding a given case considers whether a bylaw is or is not valid, the court does a different thing from affirming or annulling the bylaw itself. Legislative Council of British India. Laws are made for British India by a Legislative Council having very wide powers of legislation. This council, or as it is technically expressed, the Governor-General in Council, can pass laws as important as any acts passed by the British Parliament, but the authority of the Council in the way of lawmaking is as completely subordinate to and as much dependent upon Acts of Parliament as is the power of the London and North Western Railway Company to make bylaws. The legislative powers of the Governor-General and his Council arise from definite parliamentary enactments. These acts constitute what may be termed as regards the Legislative Council the Constitution of India. Now observe that under these acts the Indian Council is in the strictest sense a non-sovereign legislative body, and this independently of the fact that the laws or regulations made by the Governor-General in Council can be annulled or disallowed by the Crown. And note that the position of the Council exhibits all the marks or notes of legislative subordination. First, the Council is bound by a large number of rules which cannot be changed by the Indian legislative body itself, and which can be changed by the superior power of the Imperial Parliament. Secondly, the acts themselves from which the Council derives its authority cannot be changed by the Council, and hence, in regard to the Indian legislative body, form a set of constitutional or fundamental laws which, since they cannot be changed by the Council, stand in marked contrast with the laws or regulations which the Council is empowered to make. These fundamental rules contain, it must be added, a number of specific restrictions on the subjects with regard to which the Council may legislate. Thus the Governor-General in Council has no power of making laws which may affect the authority of Parliament, or any part of the unwritten laws or constitution of the United Kingdom, whereon may depend in any degree the allegiance of any person to the Crown of the United Kingdom, or the sovereignty or dominion of the Crown over any part of India. Thirdly, the courts in India, or in any other part of the British Empire, may, when the occasion arises, pronounce upon the validity or constitutionality of laws made by the Indian Council. The courts treat acts passed by the Indian Council precisely in the same way in which the King's Bench Division treats the bylaws of a railway company. No judge in India or elsewhere ever issues a decree which declares invalid, annuls or makes void a law or regulation made by the Governor-General in Council. But when any particular case comes before the courts, whether civil or criminal, in which the rights or liabilities of any party are affected by the legislation of the Indian Council, the court may have to consider and determine with a view to the particular case whether such legislation was or was not within the legal powers of the Council, which is of course the same thing as adjudicating as regards the particular case in hand upon the validity or constitutionality of the legislation in question. Thus, suppose that X is prosecuted for the breach of a law or regulation passed by the Council, and suppose the fact to be established past a doubt that X has broken this law. The court before which the proceedings take place, which must obviously in the ordinary course of things be an Indian court, may be called upon to consider whether the regulation which X has broken is within the powers given to the Indian Council by the Acts of Parliament making up the Indian Constitution. If the law is within such powers, or in other words is constitutional, the court will, by giving judgment against X, give full effect to the law, just as effect is given to the bylaw of a railway company by the tribunal before whom an offender is sued, pronouncing judgment against him for the penalty. If, on the other hand, the Indian court deem that the regulation is ultra vires or unconstitutional, they will refuse to give effect to it and treat it as void by giving judgment for the defendant on the basis of the regulation being invalid or having no legal existence. On this point, the Empress and Burah, B-U-R-A-H, is most instructive. The details of the case are immaterial. the noticeable thing is that the High Court held a particular legislative enactment of the Governor-General in Council to be in excess of the authority given to him by the Imperial Parliament and therefore invalid, and on this ground entertained an appeal from 2 prisoners which, if the enactment had been valid, the Court would admittedly have been incompetent to entertain. The Privy Council, it is true, held on appeal that the particular enactment was within the legal powers of the Council and therefore valid, but the duty of the High Court of Calcutta to consider whether the legislation of the Governor-General was or was not constitutional was not questioned by the Privy Council. To look at the same thing from another point of view, the courts in India treat the legislation of the Governor-General in Council in a way utterly different from that in which any English court can treat the acts of the Imperial Parliament. An Indian tribunal may be called upon to say that an act passed by the Governor-General need not be obeyed because it is unconstitutional or void. No British court can give judgment, or ever does give judgment, that an Act of Parliament need not be obeyed because it is unconstitutional. Here, in short, we have the essential difference between subordinate and sovereign legislative power. English colonies with representative and responsible governments. Many English colonies, and notably the Dominion of New Zealand, to which country our attention had best for the sake of clearness be specially directed, possess representative assemblies which occupy a somewhat peculiar position. The Parliament of the Dominion of New Zealand exercises throughout that country many of the ordinary powers of a sovereign assembly, such as the Parliament of the United Kingdom. It makes and repeals laws, it puts ministries in power and dismisses them from office, it controls the general policy of the New Zealand government, and generally makes its will felt in the transaction of affairs after the manner of the Parliament at Westminster. An ordinary observer would, if he looked merely at the everyday proceedings of the New Zealand legislature, find no reason to pronounce it a whit less powerful within its sphere than the Parliament of the United Kingdom. No doubt the assent of the Governor is needed in order to turn colonial bills into laws, and further investigation would show our inquirer that for the validity of any colonial act there is required, in addition to the assent of the Governor, the sanction, either express or implied, of the Crown. But these assents are constantly given almost as a matter of course, and may be compared, though not with absolute correctness, to the Crown's so-called veto, or right of refusing assent to bills which have passed through the Houses of Parliament. Yet for all this, when the matter is further looked into, the Dominion Parliament, together with other colonial legislatures, will be found to be a non-sovereign legislative body, and bears decisive marks of legislative subordination. The action of the Dominion Parliament is restrained by laws which it cannot change, and are changeable only by the Imperial Parliament, and further, New Zealand Acts, even when assented to by the Crown, are liable to be treated by the courts in New Zealand and elsewhere throughout the British Dominions as void or unconstitutional, on the ground of their coming into conflict with the laws of the Imperial Parliament, which the colonial legislature has no authority to touch. That this is so becomes apparent the moment we realise the exact relation between colonial and imperial laws. The matter is worth some little examination, both for its own sake and for the sake of the light it throws on the sovereignty of Parliament. The Charter of Colonial Legislative Independence is the Colonial Laws Validity Act 1865. This statute seems, oddly enough, to have passed through Parliament without discussion, but it permanently defines and extends the authority of colonial legislatures, and its main provisions are of such importance as to deserve verbal citation. Quote, Section 2. Any colonial law which is or shall be in any respect repugnant to the provisions of any Act of Parliament extending to the colony to which such law may relate, or repugnant to any order or regulation made under authority of such Act of Parliament, or having in the colony the force and effect of such Act, shall be read subject to such Act, order, or regulation, and shall, to the extent of such repugnancy, but not otherwise, be and remain absolutely void and inoperative. 3. No colonial law shall be be deemed to have been void or inoperative on the ground of repugnancy to the law of England, unless the same shall be repugnant to the provisions of some such Act of Parliament, order, or regulation as aforesaid. 4. No colonial law passed with the concurrence of or assented to by the Governor of any colony, or to be hereafter so passed or assented to, shall be or be deemed to have been void or inoperative, by reason only of any instructions with reference to such law or the subject thereof which may have been given to such Governor by or on behalf of Her Majesty, by any instrument other than the letters patent, or instrument authorising such Governor to concur in passing or to assent to laws for the peace, order, and good government of such colony, even though such instructions may be referred to in such letters patent or last-mentioned instrument. 5. Every colonial legislature shall have, and be deemed at all times to have had, full power within its jurisdiction to establish courts of judicature, and to abolish and reconstitute the same, and to alter the constitution thereof, and to make provision for the administration of justice therein, and every representative legislature shall, in respect to the colony under its jurisdiction, have, and be deemed at all times to have had, full power to make laws respecting the constitution, powers, and procedure of such legislature, provided that such laws shall have been passed in such manner and form as may from time to time be required by any Act of Parliament, letters patent, order in council, or colonial law for the time being in force in the said colony." End quote. The importance, it is true, of the Colonial Laws Validity Act 1865 may well be either exaggerated or quite possibly underrated. The statute is in one sense less important than it at first sight appears, because the principles laid down therein were, before its passing, more or less assumed, though with some hesitation, to be good law and to govern the validity of colonial legislation. From another point of view, the Act is of the highest importance, because it determines, and gives legislative authority to, principles which had never before been accurately defined, and were liable to be treated as open to doubt. In any case, the terms of the enactment make it now possible to state with precision the limits which bound the legislative authority of a colonial parliament. The Dominion Parliament may make laws opposed to the English common law, and such laws, on receiving the required assents, are perfectly valid. Thus, a New Zealand Act which changed the common law rules as to the descent of property, which gave the governor authority to forbid public meetings, or which abolished trial by jury, might be inexpedient or unjust, but would be a perfectly valid law, and would be recognised as such by every tribunal throughout the British Empire. The Dominion Parliament, on the other hand, cannot make any laws inconsistent with any Act of Parliament, or with any part of an Act of Parliament intended by the Imperial Parliament to apply to New Zealand. Suppose, for example, that the Imperial Parliament were to pass an Act providing a special mode of trial in New Zealand for particular classes of offences committed there. No enactment of the Colonial Parliament, which provided that such offences should be tried otherwise than as directed by the Imperial Statute, would be of any legal effect. So again, no New Zealand Act would be valid that legalised the slave trade in the face of the Slave Trade Act 1824, 5 George IV, C 113, which prohibits slave trading throughout the British dominions, nor would acts passed by the Dominion Parliament be valid which repealed or invalidated several provisions of the Merchant Shipping Act 1894 meant to apply to the colonies, or which deprived a discharge under the English Bankruptcy Act of the effect which, in virtue of the Imperial Statute, it has as a release from debts contracted in any part whatever of the British dominions. No colonial legislature, in short, can override imperial legislation which is intended to apply to the colonies, whether the intention be expressed in so many words or be apparent only from the general scope and nature of the enactment is immaterial. Once established, I think it's meant to say once established, that an imperial law is intended to apply to a given colony, and the consequence follows that any colonial enactment which contravenes that law is invalid and unconstitutional. Hence the courts in the Dominion of New Zealand, as also in the rest of the British Empire, may be called upon to adjudicate upon the validity or constitutionality of any act of the Dominion Parliament. For if a New Zealand law really contradicts the provisions of an Act of Parliament extending to New Zealand, no court throughout the British Dominions could legally, it is clear, give effect to the enactment of the Dominion Parliament. This is an inevitable result of the legislative sovereignty exercised by the Imperial Parliament. In the supposed case, the Dominion Parliament commands the judges to act in a particular manner, and the Imperial Parliament commands them to act in another manner. Of these two commands, the order of the Imperial Parliament is the one which must be obeyed. This is the very meaning of parliamentary sovereignty. Whenever, therefore, it is alleged that any enactment of the Dominion Parliament is repugnant to the provisions of any act of the Imperial Parliament extending to the colony, the tribunal before which the objection is raised must pronounce upon the validity or constitutionality of the colonial law. The Constitution of New Zealand is created by and depends upon the New Zealand Constitution Act 1852, 15 and 16 Victoria C72, and the Acts amending the same. One might therefore expect that the Parliament of the Dominion of New Zealand, which may conveniently be called the New Zealand Parliament, would exhibit that mark of subordination which consists in the inability of a legislative body to change fundamental or constitutional laws, or, what is the same thing, in the clearly drawn distinction between ordinary laws which the legislature can change and laws of the Constitution which it cannot change, at any rate when acting in its ordinary legislative character. But this anticipation is hardly borne out by an examination into the Acts creating the Constitution of New Zealand. A comparison of the Colonial Laws Validity Act 1865 Section 5 with the New Zealand Constitution Act, as subsequently amended, shows that the New Zealand Parliament can change the articles of the Constitution. This power, derived from imperial statutes, is of course in no way inconsistent with the legal sovereignty of the Imperial Parliament. One may fairly therefore assert that the New Zealand Parliament, in common with many other colonial legislative assemblies, is, though a subordinate, at once a legislative and a constituent assembly. It is a subordinate assembly because its powers are limited by the legislation of the Imperial Parliament. It is a constituent assembly since it can change the articles of the Constitution of New Zealand. The authority of the New Zealand Parliament to change the articles of the Constitution of New Zealand is from several points of view worth notice. We have here a decisive proof that there is no necessary connection between the written character and the immutability of a constitution. The New Zealand Constitution is to be found in a written document. It is a statutory enactment, yet the articles of this constitutional statute can be changed by the Parliament which it creates, and changed in the same manner as any other law. This may seem an obvious matter enough, but writers of eminence so often use language which implies or suggests that the character of a law is changed by its being expressed in the form of a statute, as to make it worthwhile noting that a statutory constitution need not be in any sense an immutable constitution. The readiness again with which the English Parliament has conceded constituent powers to colonial legislatures shows how little hold is exercised over Englishmen by that distinction between fundamental and non-fundamental laws which run through almost all the constitutions not only of the continent but also of America. The explanation appears to be that in England we have long been accustomed to consider Parliament as capable of changing one kind of law with as much ease as another. Hence, when English statesmen gave parliamentary government to the colonies, they almost as a matter of course bestowed upon colonial legislatures authority to deal with every law, whether constitutional or not, which affected the colony, subject of course to the proviso, rather implied than expressed, that this power should not be used in a way inconsistent with the supremacy of the British Parliament. Colonial legislatures, in short, are within their own sphere copies of the imperial parliament. They are within their own sphere sovereign bodies, but their freedom of action is controlled by their subordination to the Parliament of the United Kingdom.